apologize for that, man.
It's all right. When you're ready.
Here is third-party intervener in that matter, appearing as authorized representative for my client. I'll set for value in return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments and make a reservation of all of my constitutional rights, mostly the First, the Sixth, and the 14th Amendments.
Thank you. The record to reflect that the individual known to this court as Darrell Brooks is present in custody in person. He is wearing his jail attire this morning. I do want to make a record that at 8:46 p.m. yesterday, I did swear in 2 additional sheriff's deputies who would be working with our jurors through the overnight or third shift hours. I did administer the same oath that was administered to all the other bailiffs yesterday evening. Then, of course, we are open, and the jurors are here, and they will be instructed to start their deliberations. The only other thing I would put on the record is I have received information regarding the Reddit post, that there was a subsequent post from that website indicating that it was a prank. And so I don't know to what extent the Sheriff's Department is looking into that as well, but it's my understanding, based on news reports, that that entire post or site was taken down. Not the site of Reddit, but it's no longer, I believe, viewable. But there was that additional information regarding that, at least from the administrator, I believe, of that post. So I just wanted to put that on the record. And if and when, or I should say when, the investigation is completed, I will assure the parties that you will be provided with that information.
So,
go ahead.
So it's being called a prank?
Per the Reddit post itself, yes.
So we don't have any idea if that's a fact, though, right?
You're correct. I'm just putting on the record the additional information that's been reported on. And then again, once the Sheriff's Department concludes their investigation, it will be turned over to the parties. So at this point, until there's a question or a verdict, courtroom will remain open. I'm going to be working in my office on other things, and will be available, of course, if there are any questions or if a verdict is reached. So notify the parties.
Judge.
Yes.
Oh, go ahead.
No.
Go ahead.
I'm still very concerned about this whole Reddit thing after having the chance to fully read it and look at some of the language that's in it. It's very concerning.
That's why there's an investigation, sir. It's anytime there's an allegation that the integrity of this judicial process has been compromised, especially with a juror, I take that incredibly seriously, which is why I turned it over to the Sheriff's Department.
I would like Your Honor to, if it pleases the court, and if it pleases Your Honor, I would like to look at some alternatives. If I may bring up the in regards to the language, I also want to state that for the record, this did not come about from the prosecution side, from the defense's side, and certainly not from Your Honor's side. This is something that just pretty much sprang up. A lot of my concern, though, just not from just the language in the actual post, but I was kind of concerned that I was the last one to learn of this information that had been known. I wasn't aware of it until after 6:30 last night, or around that time, because I don't want to misquote the record, but somewhere around that time.
It was shortly after 7.
Oh, so it was after. I didn't know. I thought it was. I knew it was after 6:30, but I didn't want to incorrectly state the record. Your
I can
Honor.
address that for you right now if you would like.
Yeah. If it pleases you, Your Honor, I would like to request some alternatives to this issue.
What's your specific request?
My specific request would be to look into a mistrial and also any alternatives along those lines, short of that or along those lines, or a mistrial. I was looking at some, obviously, yesterday was very, very long for everybody. And as you know, because of my status here in the jail, I'm allowed to have law library time up until a certain point of the evening, and then I have to shut it down per jail policy. So I was able to find a few different things that I wanted to bring to Your Honor's attention, if I may.
Go ahead.
One being United States versus Perez, 22 U.S. 579, and that specifically, I think it's referenced because that one is pretty old in itself, but it's referenced in a lot of the other case laws that I actually found. I think, and I could be, if I'm interpreting this incorrectly, I apologize. They kind of use that as kind of like the benchmark for what they refer to as manifest necessity. That's kind of like one of the leading cases that each one references in regards to issues similar to things like this when it comes into play. And it specifically points to trial judge's discretion. And I think that's kind of like the leading one. Also, I looked at Brown versus Rushton, 572 F.3D 198, which speaks to the language is basically, it speaks to the same thing. It speaks about manifest necessity. It speaks about if there's an issue of exculpatory evidence, things of that nature. Also, United States versus Bates. That's BATES. 917 F2D 388. And that speaks of potential for an impartial verdict. Specifically, it says along the lines of impartial verdict, if an impartial verdict can be reached, or if a verdict of conviction could be reached but would have to be reversed on appeal due to an obvious procedural error in the trial. That's one of the main issues that speaks to. I also looked at Arizona versus Washington, 434 U.S. 497, and that speaks to what I was stating before. It says neither party in a case has a right to have his case decided by a jury which may be tainted by bias, and I say that because it certainly wasn't anything dealing with the prosecution. They had nothing to do with this. The defense had nothing to do with this, and certainly you, Your Honor, had nothing to do with this. But just for the concern factor, the language it's pretty clear that this, if not directly came from a juror who sits on this panel, it came from someone who sits in this courtroom every single day. The language, it directed towards you, Your Honor, directed towards having clear bias towards the defense. Some of the things that they quoted of having knowledge of is extremely concerning. Extremely concerning. And then going back to some of these case laws that I cited, it talks about something to the effect of the ends of public justice. But I think that is leaning more so towards the judge's discretion, I would say, at least from how I was interpreting it. Obviously, I'm not educated in a lot of the laws in itself, but how I was interpreting it, this is definitely a concerning issue. It's definitely something that I would request Your Honor to take a long look at. Look at some options. Look at some alternatives. And those case laws I cited talks specifically about that, options that you, Your Honor, can look at and use your discretion to see if it's appropriate in any way. But I'm extremely concerned about this. If anything, for cautionary reasons, I believe, Your Honor, that you definitely should take a look at everything I'm saying here in these case laws and
What's the request, though, that you're making based upon the case law that you cite? I heard in there mistrial, but I want to make sure I understand your request for relief and what it is.
You said request for
relief.
Relief.
What are you asking me to do based upon the information that the limited information we have about the Reddit post and this trial?
I guess my request would be, because of the concern of this, to look at a mistrial, or at the very least a discharge of the jury at this time, so this can be resolved. This is alarming, to say the least. This post, and I don't know what Reddit is, to be honest. I've never heard of it or used it, so I don't know the extent of. It's almost like this could be like a snowball type of thing. It can start with something that's this small, and then it can snowball out of control into something totally different. I don't know the extent of this website. I don't know who. Well, I think the name of the person who sent the who alerted the clerk, of course, to this post. I think his name is in the email. But then that even begs the question of, how did this person come across this site? What is their significance to this? What is their role in this? It's just so many questions, and I mean, clearly this points at the court's integrity. It points at your integrity, Your Honor. It's alarming. It's very alarming. And if there's a chance that there can be hidden bias in this jury, it needs to be addressed now rather than later. This is very concerning.
Well, thank you for bringing up your concerns. Let me turn to the state if they want to respond, and then see what other issues they want to cover this morning.
Judge, the original post was on a subreddit thread called Justice for Darrell. That's the copy that the defendant has in front of him. That post was edited last night, claiming that it was a prank from the start and that the original poster didn't think it would get that far out of hand. The way that Reddit works, the only person who can modify the content of the original post is the original poster, and because the jurors have no access to any electronic devices, I think it's safe to say that our 12 jurors back there are not the original poster. So I think that puts that issue pretty much to bed. It's still obviously under investigation because the court takes it so seriously, but there really is no actionable or any real reason why we should doubt the jury's being unbiased in this case.
I object to that on the grounds, Your Honor, that, like you just stated, it's an investigation going on. And if there's an investigation, then that clearly says that something is amiss. We have 15. We have 15 jurors. There's still too many questions that we don't know. Too many. I don't think anything's put to bed because we don't know. It's unfair to say that the issue is put to bed when there's still so many questions left out there. I'm sure you reviewed it yourself, Your Honor. You see the language in this, whatever this thread. I don't know. I don't know what this is. It's clearly a post from somebody who has intimate knowledge of the trial and what's going on in the trial. I don't think. I mean, common sense would tell you that this is someone who's very close to the case, whether they were intending to be funny, whether they were intending to try to prank the court or anything like that. We don't know. That could be anybody's guess. The language in this, the way that it's formatted, they lay out 4 specific points of what they think. They point to certain language in the case. They make references to saying when we were in the room. They got certain feelings from where they specifically refer to themselves and a group. That would be we, plural. They say, and I have to admit, I am biased against the defendant for the horrible acts he did. And they attack you, Your Honor. They clearly attack you. This is if this is someone's idea of fun, is anybody's guess, but I don't believe that it is, clearly by the way it's formatted and by the language that is in it. This is clearly someone with intimate knowledge of the case and what's going on. Clearly. There's no other way to interpret this. You can tell by what they're laying out in the language that they're speaking with, that this is clearly someone close to the case. And because of that, it still has to be, I'm informed of the investigation, but there's still too many questions left in the air just from this. How can we say anything's put to bed when there's still an investigation? For all we know, what if this turns up that it was someone on the jury, or what if it turns out that more people are involved in it than just whoever this anonymous person was who left the post. It's too many questions and it's too concerning. What if something like this springs up again at the last minute? We've been going through the trial now for basically 3 weeks, the better part of 3 weeks. And even in court days leading up to the trial, we've never had anything like this happen. Nothing like this has been brought to your attention. Nothing like this has been brought before the court's attention. This just came out of the blue, and now all of a sudden it's being labeled a prank. Is that because they were found out? I mean, it begs so many questions. It's too uncertain. It's too concerning, and it's too alarming. It's too alarming to just overlook and say, "Oh well, we'll just set it to the side and let them." No, this there has to be some type of alternatives, and something has to be done. Something, and if that's a mistrial, if that's discharging a jury, if that's some other type of alternatives that can be looked at, I'm sure that these case law speaks to other options that could come into play. They deserve to at least be looked at, if anything, to protect the integrity of the trial. I find it very hard to believe that this close to the trial being over, and all of a sudden these issues are being raised. So this is obviously not a prank, and it's obvious that this is someone with intimate knowledge. It's very clear to me.
Well, let me address your concerns, sir. I cannot make conclusions at this point about whether this is legitimate or a prank. What I know is as follows. I received the information about the subreddit post at approximately 9:30, 9:40 yesterday morning. I alone made the decision to withhold advising the parties because of where we were at in the trial, because there was nothing in that post. It was an anonymous post that would lend credibility to that it was in fact one of these jurors. But out of an abundance of caution, I referred it to law enforcement because it is very serious if the integrity of these proceedings were to be put at issue by a juror. I'd remind you though, every single day these jurors were read the bulk of jury instruction 50. They all took an oath, and I have no reason to doubt that they would violate that oath at this time. So I took and I made the decision to withhold telling the parties because we were in the middle of instructing the jury. I was in the middle of instructing the jury, and I wasn't going to delay the proceedings because it was so speculative at that point and remains speculative at this point. As you know, the case went to the jury. I brought this up. I waited about a half an hour once the case went to the jury. Frankly, we had had a long day. I wanted to get a bit to eat, and then I wanted to come back out and make a record of what I had. Once again, the forensic unit with the Sheriff's Department has taken lead of this investigation. I'm not a part of that investigation. Law enforcement will handle it. From my perspective, not only did the Clerk of Court's office receive emails regarding this, it sounds like the district attorney received emails. I may have even gotten one, I don't remember the time, it was later, regarding the post. Frankly, people figure out my email all the time. It was not solicited by me in any way, and I did not respond to it, and I simply forwarded that email onto law enforcement. So it's pretty clear to me that a lot of people have access to Reddit. I personally am not a user of Reddit, so I don't know the ins and outs of it, other than it is a social media site where people can create accounts and post, and there can be like chat rooms, for example, or just various, as this is called, subreddits. And at this point, you've requested a mistrial. You've requested that I discharge the jury. I'm declining to do that at this time, sir. Again, I need to make decisions based upon the record that's before me. And right now, the record is speculative. There are no facts to support a mistrial or discharging the jury. I trust the parties will continue in their own independent investigations, that you will continue reviewing case law, make whatever requests that you deem appropriate. I certainly will take time to look at the cases you have cited, to see if there's anything based upon the requests that you have made that I would need to further review. But at this time, I do not see grounds for a mistrial. I do not see grounds to discharge the jury. That is how I will address it at this point. I know the state, I believe, wanted to address something else. I'm not sure if that was it, but you had deferred to Mr. Brooks, so go ahead. Is there anything you want me to address or at least bring to the court's attention at this time?
Just a minor point, Your Honor. You had noted the defendant is in his orange jail uniform today. It's my understanding the jail did offer him the ability to put on his street clothes, and he declined, so I just wanted that on the record. There may be occasions where this jury has to be brought into the courtroom for one reason or another, and he should be in civilian clothes if that occurs, if he chooses to.
It's a good point to bring up. It is possible the jury would need to be brought out if there is any question that I need to answer on the record. If for some reason the technology were not to be working appropriately when videos or other evidence are displayed to them. And so it is possible that the jury would need to come out. Of course, they'll come out if and when a verdict is reached. So I would certainly give you the opportunity, sir, if you want to change into the street clothes, that I would certainly direct the Sheriff's Department to make that available for you, should you choose.
Isn't it my choice?
Yes, it is.
So why do I need to be in street clothes? Why does that need to be on the record? That
your choice should be placed on the record, sir.
If not, I was offered to be in street clothes. If I made it the choice.
Do you dispute that, sir?
Yes, I dispute it because it's my choice.
Well, no. Do you dispute that you were given the choice this morning?
At this point, there's no reason why that should be on the record. That if I was not offered street clothes, what relevancy does that have to?
Could have potential relevancy later on if
Why?
you were to challenge that you and claim that you were required to wear your jail uniform or jail attire. You're not required. This is a trial. You have the right to wear street clothes, and I will certainly provide that opportunity should you wish to change at any point in time. But what you're telling me is it's your choice to be in jail attire. I'll respect that choice, of course.
So why does that need to be stated for the record?
I just indicated why, sir. So
I don't see the relevancy of it.
all right. At this point, unless there are any further issues, I am going to go back into my office. The courtroom will remain open, and we'll let you know when the jury communicates with us, either about a question or verdicts.
There is something that needs to be addressed. Subject matter jurisdiction.
The court declines that. I'm stepping off.
Why hasn't it been proven on the record yet? And I.
Record and State versus Brooks appearances are as they were before. I would make just one note that Mr. Brooks is now present in a suit. And I will also advise that at 9:43 a.m. this morning, I was advised that the jury had reached verdicts in this matter. And without anything further, I'll have the jury brought out.
Your Honor, I don't consent to being called that name and would like to address subject matter jurisdiction for the record that has yet to be proven.
Your objections are noted. I will not be addressing subject matter jurisdiction. Please bring the jury out.
Would it be proven for the record, Your Honor?
Just a reminder to everyone that I do expect everyone in the courtroom to demonstrate appropriate decorum and courtesy as the verdicts are read and refrain from audible responses. Any disruptions may result in removal from the courtroom.
Your Honor, is that a tacit agreement not to address subject matter jurisdiction for the record?
Jury's coming in. All rise, please.
I respectfully object to that ruling, Your Honor, and request the legal reconsideration of your ruling for the record.
Your requests are noted, sir. I will not be addressing that further.
For the record, may I respectfully reject that ruling and take exception to that ruling, Your Honor? Is that a tacit agreement and a judicial determination that you don't have to answer that question as a public servant, Your Honor? For the record, may I request the legal or factual basis for your ruling, Your Honor?
It might have been a false alarm.
For the record, may I respectfully request
Juris.
a written judicial finding of fact and conclusion of law on this issue, Your Honor?
All your requests are noted for the record. They all are denied, sir. All rise. Jury's coming in.
For the record, may I respectfully move for an interlocutory declaratory appeal on this matter, Your Honor?
Denied.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction?
Denied.
Based on what law or fact, Your Honor? Is that a tacit agreement that you don't have to answer that question? For the record, Your Honor, as a public servant? You don't have to address admiralty law or common law if this court is operating under admiralty law?
I will not be addressing any of those issues.
Respectfully
Thank you, everyone.
object,
Please
Your
be
Honor.
seated. Ladies and gentlemen of the jury, have you picked one among you to be the foreperson? All right, and I see it's juror number 11. Have you reached verdicts on all 76 counts?
Yes.
All right, would you please hand all of the forms to the bailiff?
Your Honor, seeing as that we've reached a verdict, is it necessary that I have these shock devices on my ankles?
confirm that there are 76 signed verdicts and 76 unsigned verdicts, which would be what I would expect. All right, I will read each one into the record. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information, dated this 26th day of October 2022, signed by the foreperson, juror number 11. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes.
Burn in hell, you piece of shit.
Hey, you are to be removed right now. You will not do that. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. And I should state as to count 2, it was signed and dated by the foreperson, same as to count 3. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information, dated this 26th day of October 2022, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 8 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 10 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 11 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 12 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 13 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 14 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 15 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 16 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant guilty of first-degree recklessly endangering safety as charged in count 17 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 18 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 19 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 20 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 21 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 22 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 23 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 24 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 25 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 26 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 27 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 28 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 29 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 30 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 31 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 32 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 33 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 34 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 35 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 36 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 37 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 38 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 39 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 40 of the information, dated today's date, signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 41 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 42 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 43 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 44 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 45 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 46 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information, dated today's date, signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 51 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 53 of the information, dated today's date and signed by the foreperson. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 54 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 55 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 56 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 57 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 58 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 59 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 60 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 61 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 62 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 63 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 64 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 65 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 66 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 67 of the information, dated today's date and signed by the foreperson. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. Did the accident involve death to Virginia Sorensen? Answer, yes. Dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Leanna Owen? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Tamara Durand? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 71 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jane Kulik? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Wilhelm Hospital? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 73 of the information, dated today's date and signed by the foreperson. Did the accident involve death to Jackson Sparks? Answer, yes. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 75 of the information, dated today's date and signed by the foreperson. We, the jury, find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information, dated today's date and signed by the foreperson. Mr. Brooks, would you like me to poll the jury?
Yes.
Members of the jury, I'm going to ask each one of you individually to stand up, identify your number for the record, and then state whether the verdicts read in open court are your true verdicts. I'll start with the foreperson. And I'll read your numbers first so it's a little bit easier. So juror number 11. Were the verdicts read in open court, or are the verdicts, let me rephrase that. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 3. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 6. The verdicts read in open court, are those your true verdicts?
It is.
Thank you. Juror number 14. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 19. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 27. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 34. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 41. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 45. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 46. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. Juror number 48. The verdicts read in open court, are those your true verdicts?
They are, Your Honor.
Thank you. Juror number 51. The verdicts read in open court, are those your true verdicts?
Yes.
Thank you. I should state for the record, I did have the alternates brought back in. Obviously, they did not deliberate, but it was important to have them because there are certain instructions I give at the end. All right, Mr. Brooks, are you satisfied with the polling of the jurors?
No.
I'm sorry?
No.
The court is so satisfied with the polling of the jurors. The court now accepts the verdicts. Ladies and gentlemen, on behalf of myself, the citizens of Waukesha County, and both parties here, I want to thank you for the time and attention that you've spent on this case. Your service in this case is now concluded. There is no requirement that you maintain secrecy concerning what happened in the jury room, but you do not have to discuss the case with anyone or answer any questions about it. On behalf, again, of the court and all of the parties, we thank you for your service over the last 3.5 weeks. You are discharged and free to go. All rise for the jury, please. Thank you. Be seated. Anything from the state at this time?
Your Honor, the state moves for judgment on the verdict as to each and every count.
Anything from you, Mr. Brooks?
What is judgment?
Given the verdicts from the jury here today, the court will enter judgments of conviction based upon the verdicts on all 76 counts. Court will also revoke bond. In this case, I plan on bringing the case in Monday, this coming Monday, the 31st at 1 p.m. to address further scheduling. What I would ask the parties to do between now and then is to determine how long you think each side will need to present their sentencing remarks, whether you anticipate anyone speaking on your behalf, if so, how many, how long, so that I can then look at my calendar and adjust and make sure that I have the appropriate amount of time to do that. I'm not going to sentencing on Monday. It is just for further scheduling at 1 p.m. before my afternoon case.
Judge, would you be willing to consider persons appearing by Zoom for sentencing?
Yes, I would not do anything different than what I've been doing since we started utilizing Zoom, and that is to make it available for both victims and family members of the defendant if they so choose to make statements over Zoom.
Okay, thank you. That
You're welcome.
helps us in our planning.
All right. All right then. Thank you, everyone. We are adjourned for today. We'll see you all on Monday.
gallery saying, "Burn in hell, you piece of bleep." He was removed from the courtroom, but I imagine sentiments shared by so many in the Waukesha community after the events of November 21st, 2021.
Let's get out to Brett Lemoyne, who has followed this trial from the very start. Brett, it was a long trial. The state calling 57 witnesses. Brooks himself called 10. The verdict, though, coming back within hours.
Yeah, that's exactly right, Kim. In fact, the jury got this case just last night at about 6:30, and they went until 8 o'clock last night. They resumed at 8:30 this morning, and we're told they reached their verdict at around 9:45. I also want to address some of the reactions that are happening outside of the courtroom today as these verdicts have come down. We've seen a number of cars drive by in front of the courthouse, honking their horns. In fact, I saw one driver raise up his hands, or at least one hand, from behind the wheel in jubilation for what this verdict means for this community. So a lot of reaction already taking place. And as you mentioned, yes, there was that one individual that did have an outburst early on in court. You want to keep in mind the timeline of this too, right? This is something that's been going on now for almost a month. For 18 business days, this trial has been taking place. A lot of people have been waiting for this moment since last year. And again, we're approaching the 1-year anniversary of this tragedy in just a matter of days on November 21st. So there was a lot of people that were waiting patiently for justice to be served in this case, Kim.
For that moment, Brett, you're so ingrained in the Waukesha community. Can you speak to just the different families you've interviewed, the different stories you've done on the impact of those events now almost a year later?
Yeah, and Carl, it hasn't just been, the people who sadly died or the people who had suffered injuries after this attack. It's been their family members, their churches, their schools. This has had such a huge footprint on Waukesha over this last year. It's really difficult to get your arms around. There have been so many people that have told us their stories, where they were on the parade route, how they've been impacted, how they've been healing physically and emotionally. And as you know, there is already work underway to memorialize the victims. There'll be a memorial at Greedy Park here in Waukesha, a rather large memorial for the victims, and a separate memorial that will also be on Main Street where this tragedy took place.
Brett, this trial difficult for so many reasons, not the least of the conduct inside the courtroom, the defendant Darrell Brooks. We never knew how this was going to go, if he was going to be cooperative, if he would be allowed to stay inside. What was it like for you watching the back and forth between the defendant and Judge Darrell?
Yeah, Kim, it almost got exhausting just from a viewing standpoint over the last few days here because the back and forth was quite routine. It was almost every single day. There were disruptions. Almost every single hour there were disruptions, and it seemed like it was just not going to stop. These were obviously delay tactics, especially when you consider the district attorney had thought maybe only 5 to 7 business days they needed to present their case, and here we are on day 18.
And you were there for each and every day. Brett, one of the things about this trial with Darrell Brooks representing himself, the state was very careful to avoid having direct family members of the victims, specifically the 6 who died, testify, I think because of the realization that Darrell Brooks could be cross-examining them as a result. What were some of the moments that we didn't see in the gallery, the people watching these proceedings as testimony went on?
Yeah, I saw a number of people in the gallery every single day viewing this trial. One family in particular, the Pudliners, you might recall, Tyler Pudliner was...
Brett, I'm going to stop you because you can't see behind you, but there's a family member that's leaving that you may want to talk to, so we're going to let you break away and get that. But we are covered here. We've got Brian Paulson, who has also been following this, breaking down what's been going on for us on Wake Up And we're going to get to you in just a moment, but first.
A number of different crews all throughout the area, Brian. We'll get to you momentarily. You've been such a big part of our coverage on Wake Up. Julius Kim, a defense attorney here in Milwaukee, has been a large part of our coverage as well in the evenings. A legal expert joining us now via Skype. Julius, I'll just start with the basic question. Your reaction to the guilty on all 76 counts verdict?
The verdicts really probably didn't come as a surprise to everyone based upon what we've seen, the evidence that was presented, and the lack of a strong case by Mr. Brooks. So I think that the verdicts aren't a surprise. I think that this case has been a tremendous test, not only for the prosecution, just in coordinating the sheer volume of witnesses and evidence in this case, but it was also a test for the judge. Certainly, Mr. Brooks was testing her patience, testing her judicial acumen to make sure that she protects the record in this particular case. But the case was also a test for the entire criminal justice system, because obviously this case was unusual. It was not like any other. There were a lot of obstacles in the way, but in the end, I think that justice was done and justice was served, and I hope that the Waukesha community and all of southeastern Wisconsin can start to move forward a little bit, and that this contributes to the healing process now that there have been verdicts in this case.
Julius, we're going to bring in Brian Paulson, who joins us this morning. Your reaction and questions also for Julius.
Well, one of the things that stands out to me is, Julius, throughout this trial, we obviously saw the judge seemingly bending over backwards to give the defendant the opportunity to be in the courtroom, the opportunity to be asked the same questions over and over again. And it would seem that that was an effort to avoid any concerns on appeal, maybe a potential mistrial. Over the course of these 17 days, did you see anything that might raise questions or concerns that Brooks might have some sort of an avenue on appeal, which would be the one thing I guess people have left to wonder about?
Yeah, that's a good question. Judge Darrell did a fantastic job of managing this trial, and I think a lot of what we saw in terms of her being patient and being somewhat lenient with Mr. Brooks in terms of his outbursts, et cetera, was not only her trying to protect the record in the case, but I also think Judge Darrell just wanted to have Mr. Brooks present in the courtroom if at all possible, recognize the situation he was under, and she knows that it's always best to have a defendant in the courtroom at his or her own trial. Now, as to an appeal, I think that the record during the entire case was actually pretty tight, pretty solid. Judge Darrell did a very good job of protecting the record, explaining her decisions along the way. If the way I look at it, if there's any questions that still kind of linger out there, one question might be the decision at the very outset of the case as to whether Mr. Brooks was not competent to stand trial. I think that everyone can agree, and the Court of Appeals will also find that he was competent to stand trial, but whether he was competent to represent himself. And Wisconsin has an additional standard with regards to people representing themselves. And there was no separate evaluation that was done on Mr. Brooks to make that determination. Judge Darrell relied on some evaluations that were done for essentially an insanity, potential insanity defense, and just anecdotal evidence of Mr. Brooks' prior counsel. An examination doesn't have to be done for that particular purpose, but because it wasn't done, that's going to leave some questions. I think also just Mr. Brooks' own antics, once it became clear that this trial was going to go forward, and with him taking off his shirt and acting out, made people start to wonder while the case was going on whether he is in fact competent to represent himself. So that might be one lingering issue that may still have to be answered down the line.
Julius, if you don't mind standing by, there's a lot more that we want to ask you, specifically about the state's job in getting this case to the guilty verdicts. But we do have a number of different reactions coming in the moment, of course, people coming out of that courtroom. Amelia Jones is one of our crews outside of the Waukesha County courtroom, hearing from people who were inside when those guilty verdicts were read.
And we're talking to someone right now. I'm going to put my microphone in here so you all can see.
Case and just her professionalism. She needs a month's vacation. I think Waukesha County should pay for her month's vacation just to be able to sit back and just get a breath in.
And for you, why come today? It's obviously still fresh for you. Why come?
Because I needed to see. Well, I didn't see firsthand, but because I was outside of the courtroom, but saw it on my phone and that stuff, that justice is served for all the people that were injured and, the families that lost a loved one in this this tragic event. You know, it's a big tragedy.
Now, can I ask, were you at the parade when this happened?
I was 2 blocks away. I do deliveries, so I work for myself, and I was on Park Avenue when I heard the parade going on. I knew the parade was going on. I had several friends that were down there. Several of them got injured. 3 of them are dead. So like I said, I was 2 blocks away doing a delivery, and I heard the bands and everything else, and I was delivering, and all of a sudden the blood-curdling screams, and I'm like, what is going on? I'm like, okay, I logged off my apps. I went home, turned on the TV, and I was utter shock that this happened.
Yeah, ma'am, your initial reaction to the verdict. You were in the court.
I was not in the courtroom. I was outside the courtroom, and I knew he was guilty. For him to deny it was a brief moment of relief, but then all the pain comes back. Yes, there's a little closure, but not much, because we have to go through our daily lives not being around the ones that we care about, and the mother of Jackson will never be able to hold her son, where Brooks was whining about him not holding his newborn baby. What about Jackson? It's hard for all of us.
Can you describe kind of what it felt like, what it sounded like, looked like as soon as they read those guilty verdicts? Even outside the courtroom.
Justice! Justice has been served. Justice.
What was the reaction from the people you were surrounded by when?
The same as mine to justice. And they're questioning a lot on, well, why do they have to read through it? I was like, because each one of those person means something. Their lives matter. Anybody that is not here, the state was presenting in those that could not speak for themselves because they're no longer with us. So justice was served.
We know this trial has been very emotional. It's almost been a month long. How did you all with the Waukesha community stay strong, get through it?
We just hold each other up and help each other when we can. We set up a lot of GoFundMes and that stuff, and part of a Waukesha Strong community, which I am part of. We're all together in this. We're trying to uplift and spread hope that, and we do have new barriers for this not to happen again, but it shouldn't have happened in the first place. He could have went down Pleasant Street. Simply. I was doing deliveries. I knew I didn't realize that the parade was going on. I'm like, oh wait, the parade is today because I saw the barriers. Duh, you see the barriers, something's going on. Like in the summertime, we have Friday Night Live. The same streets are blocked off for Friday Night Live. Go down a separate street. I was driving down Waukesha during the parade and that stuff. It's easy to go around there, but the barriers,
What is your first and last name in this building?
Lori Hoagland, Laurie Hoagland.
You mentioned you had new dozens who were injured, and you had 3 friends who were killed. Do you mind sharing who your 3 friends are?
Tamara Durand, Jane Kulich, and I knew the family of Jackson Sparks.
I'm so sorry. Thank you so much.
Thank you.
We are getting more reaction as the verdicts have been read. 76 counts. Darrell Brooks found guilty on all 76. That woman, a member of the community, wasn't at the parade, did not lose a family member directly, but obviously the entire community has been affected.
Yeah, this is obviously a huge moment we've been waiting for, the community's been waiting for. I think the next big step, of course, is what is this going to mean in terms of his sentencing, and that we heard the judge say is not going to be determined until sometime next month, because on Monday, October 31st, she's going to have a scheduling conference to talk about that sentencing. What I can tell you is what he faces. The 6 homicide counts alone carry life sentences, so a maximum of 6 consecutive life sentences just on those 6 charges. The rest of the charges, there are all sorts of different felony levels, and when you add them all up, it's a potential 555 years of additional time in prison on top of the 6 life sentences. And that doesn't even count the penalty enhancers for using the SUV as a dangerous weapon. So obviously, this is well beyond, he's going to serve his life in prison.
Yeah. I believe we still have Julius Kim standing by, if we can go back to him as well for a more legal analysis about the work the state really had to do here. And Julius, of course, the burden of proof is on the prosecutors in a criminal case like this. What did you think of the job they did, really taking the jury foot by foot through the parade route and connecting so many of the dots of what and where Darrell Brooks was and what he was doing before and after the attack?
I think they did a great job. There was not a lot of issue with regard to the provability of the case, in my opinion. And from a technical standpoint, I don't think that there was an issue with regard to ID and that type of thing. I think that this was a logistical challenge for the state, in all honesty. There were so many counts that were charged, so many witnesses and victims that they needed to account for and manage during the course of this trial. They needed to work with a lot of evidence, hundreds, if not thousands, of reports and digital evidence. So they did a really nice job compiling the case together and presenting the case in a very logical way. I thought that one exhibit with all of the victims' names on them along the parade route was very effective. I thought that the way they presented the case was effective and it made sense, and chronologically it was easy for the jury to understand. So kudos to the state for doing a good job in terms of organizing the materials, presenting the case in a very clear fashion, and in their closing arguments, not over-prosecuting the case. They knew they had a strong case, and towards the end of the trial, they didn't over-prosecute the case by prolonging this case getting to the jury longer than it had to.
As we continue to get reaction from those who were in the courtroom, those who have been affected by the losses, let's jump ahead to Monday, when the judge has said this is going to be a time to schedule when the sentencing will happen, and finding out how many people want to speak, give victim impact statements. There's 76 counts. Could 76 people be allowed to speak, or how does that work?
Yeah, they have the right to do that. But I'm not sure that all 76 people and all interested parties are going to actually make a statement. There's also the option of submitting statements in writing, and I think that the state is going to encourage that as well. I know Judge Darrell is going to consider everything, whether it's written down or statements being made via Zoom or in person in court. The reality of the matter is that Brian is absolutely right that Mr. Brooks is now facing 6 life sentences, and I just want to qualify that by saying that each one of those sentences is mandatory. So as soon as we heard the verdict on the first count, he was guilty of first-degree intentional homicide. As far as I was concerned, it was a done deal because it's a mandatory life sentence here. There's really not too much for Judge Darrell to ponder here. It's just whether she wants to run these counts consecutive to each other or to add on to a life sentence already. But life is life. Even one count mandates a life sentence for Mr. Brooks.
And if I may, the 6 people who were killed, they are Jackson Sparks, who was just 8 years old. He was a member of the Waukesha Blazers. Jaden Coolidge, 52 years old, walking with her employer, Citizens Bank. 4 members of the Dancing Grannies. They were Virginia Jenny Sorensen, who was 79 years old, Leanna Owen, who was 71, Tamara Durand, who was 52 years old, and Willem, who went by Bill Hospital, who was 81 years old. He was a husband of one of the dancers.
Julius, throughout this case, obviously, Darrell Brooks spent a lot of time on the sort of sovereign citizen issues, raising questions of jurisdiction and refusing to respect that the court had jurisdiction over him. He's not the only person out there who's using these sort of sovereign citizen arguments in court. There are more of them out there. Is this having any success? Did we learn anything from this case as to how to handle disruptive pro se defendants making these kinds of arguments? What's your takeaway on that?
Yeah, with regard to the sovereign citizen stance that Mr. Brooks and a lot of people have been taking, I think that this trial is probably a good lesson in terms of how the court system is going to deal with it. They're going to ignore it because the laws in Wisconsin don't recognize this whole sovereign citizen thing. And you can see how far that got Mr. Brooks. I think that this was all kind of new territory for the state and for Judge Darrell, quite frankly, because this was a high-profile case and one where we had a pro se defendant claim sovereign citizenship, which is unusual in and of itself. And I think that Judge Darrell handled it as best she could. She acknowledged certain things, but she also moved on, acknowledged the objections, acknowledged his positions, but ultimately told him that's for the Court of Appeals to decide, and I'm moving forward with this case.
You know, I've been talking about this just off the air with friends and colleagues and family members about whether or not what's happening with this case is the type of thing that'll be discussed in law schools in the future. I mean, is this case going to be something that will be studied in terms of how Judge Darrow handled not only a pro se defendant, but a very disruptive pro se defendant?
Yeah, I think that's a great point, Brian, because I think all of us kind of knew what the end result was going to be in this trial. I was watching this trial more for those things. You know, how does the criminal justice system deal with pro se defendants? How does the criminal justice system deal with defendants that have mental illness? How do you deal with defendants that are disruptive in court? And we could see how Judge Darrell leveraged technology to her advantage. You know, 10, 20 years ago, I'm not sure that this trial would have looked the same way. We could have very well have seen a bound and gagged Darrell Brooks in the courtroom 10 or 20 years ago. I've seen those situations happen, but because of technology, those things didn't have to play out. So this trial definitely is going to be conversation for lawyers, for jurists, for judges, and in classrooms all around for a long time, because there's a lot of lessons that can be gained from watching how this all played out.
Julius, thank you. It was certainly fascinating seeing how this case played out. I think today helps to refocus things on the victims, on the families who lost 6 loved ones, 61 others injured. Darrell Brooks will be going to prison for the rest of his life as a result of that. Let's switch gears to Gabby Mays, who's in the newsroom right now. And Gabby, you've been following some of the reaction that's been pouring in from all over the state, all over the country as a result of this guilty verdict today. What have you seen and heard?
Yeah, and we knew that we were going to get a lot of reaction, especially online. Let's go first to Senator Ron Johnson. Senator Johnson says, quote, "Justice has been served for the victims and families of the Waukesha Christmas Parade massacre." He goes on to say, "I hope and pray this verdict will bring them some measure of peace and closure." He goes on to also say, "I want to thank Judge Darrow for her service and patience putting up with this murderer." That's the end of his quote. Let's move on now to another person here. We've got Josh Call. He's currently in office right now. He says, he's the Attorney General, excuse me. He says, quote, "My thoughts are with the people of Waukesha who have responded to this horrific attack with such incredible resolve, unity, and strength." Again, there have been a lot of reaction coming in. If you follow my Twitter account, we kind of have most of what's been happening right now as far as the reaction in regards to this case. And again, it's really interesting just to see, because this has been going on for quite some time. So, you know, people have really wanted to, you know, share their side of the story and explain kind of what they think about this trial. We'll have more reaction. We're kind of just bringing it in. We'll have more reaction from the city as well as the city administrator and also the mayor. That's coming up. For now, I'll send it back to you guys in the studio.
Gabrielle Mays, thank you so much. Brian Polson also following this story minute by minute. We weren't sure what to expect when the verdicts would be read, and we just saw a different Darrell Brooks.
Yeah, you know, we were kind of taking notes as you watch, as that verdict went on for a long time. It was 28 minutes for Judge Darrow to read all 76 of those verdict forms. And during those 28 minutes, Darrell Brooks did not move. For all of the antics, taking off his shirt, scuffling with the court bailiffs, for all of the interruptions, he held his hands clasped above his forehead with his head looking down, and he did not move for 28 minutes as he listened to that verdict. So obviously a very different Darrell Brooks listening to the verdict than the one we've seen throughout the trial.
There have been so many different moments over now day 18 of this trial, 3.5 weeks. It seemed every day was something different. You would say often expect the unexpected. Are there particular moments or days, things that happened in that courtroom that you will remember from this?
Well, I think there's so much to remember, and obviously most people are unfortunately going to remember the antics, right? Because they were so unusual and in some cases so alarming or frustrating to watch, because you just wanted to see the case move forward, and here were all these interruptions and delays. But in terms of the testimony, the things we saw, obviously the very emotional testimony. I still remember one of the witnesses who was a coach of the extreme dancers, Alyssa Kajewski, just with tissues tearing up the stand as she had to watch the children being run over. I think it was moments like that that really stood out. But then we got to the end of the trial, at the later part of the state's presentation, and that's when they really started connecting the dots. And they literally, the key to the case was they literally had the key in his pocket, the key to the SUV. For all of the times that Brooks would question witnesses about, could you have ID'd that person? Could you really see him? Did you get a license plate number? he had the key to the car in his pocket when they arrested him. There were all the photographs that showed him at different spots along the route, both before and after, next to the car, in the music video standing next to that car. It was his mom's vehicle. His information was in there. The state, I think, on those last couple of days of testimony, really sort of nailed down the ID part of it. But in the end, it comes back to the people. It comes back to the people who were killed and people who were injured. And that emotional testimony is what I think we'll all remember most.
You talk about the people. 6 people died. The youngest, Jackson Sparks, was 8 years old. We remember them and their families right now, but we're going to take a break. And when we come back, we're going to wrap up the verdicts. But Darrell Brooks found guilty on 76 counts related to the Christmas parade tragedy.
Our coverage of the Waukesha parade trial continues. Darrell Brooks guilty on all 76 counts. And we want to get back outside to Brett Lemoyne, who was inside court for so much of these 18 days, now outside the Waukesha County courtroom. Brett, what has the mood been like as you've seen people come out of the gallery and just drive by in Waukesha?
A relief, really, Carl, that this is now over. And certainly there's a feeling here in Waukesha that this community will be continuing to heal for a very long time. We just got statements from Waukesha Mayor Sean Riley, the police chief, and the fire chief as well. They obviously were all impacted by this tragedy, responding to it in the moments after it unfolded. You can't go anywhere in Waukesha without seeing that Waukesha Strong logo that we have seen now for the last 11 months. And there's a feeling that while it's a relief that this phase is over, that the healing is going to continue for many years to come.
Brett Lemoyne, thank you so much. Again, a part of Waukesha community yourself, and to be covering this with all the emotion. And it has just been a tough year and a tough 3.5 weeks for the community.
I don't know if you get closure from this for the families, especially the ones that lost loved ones in the parade attack, but it's at least a moment of healing as you move forward as well. We're getting a number of different reactions, as you heard from Gabrielle Mays earlier, Senator Johnson, Attorney General Josh Kaul. Now we are getting a statement from the mayor of Waukesha, Sean Riley, saying, quote, "I'm thankful that the jury found the defendant guilty on all counts. We can now refocus on taking steps forward as a community and continue the healing process."
Many first responders were on the scene that day of that parade, November 21st, if not in the parade, but responding to those who were hurt and injured. We are hearing from the fire chief, Steve Howard, saying the decision can now allow our fire department and our community to take another step on our pathway to recovery from this horrible trauma. We thank everyone for their support for our department and city.
And so many of those not only there that day responding in the moment to something. We had one of the testimonies during the trial saying this was a person who was in combat and hadn't seen anything like what he saw in Waukesha that day. Many of those members of law enforcement also testifying as part of the state's case against Darrell Brooks.
Darrell Brooks found guilty of all 76 counts. His bail has been revoked. That means that he is now in prison awaiting sentencing. And again, the most serious charges for the 6 lives that were lost that day.
Those 6 people, 8-year-old Jackson Sparks of the Waukesha Blazers, 52-year-old Jane Coolidge, who was with her employer, Citizens Bank. And we've learned so much about the dancing grannies in the last 11 months. 3 members of the dancers, Ginny Sorensen, Leanna Owen, Tamara Durand, and a husband of a dancer, Bill Hospital, the 6 lives lost that day on November 21st.
We're going to take a break in our coverage, but at 1 p.m., the prosecutor will speak about all this is what the 3.5 weeks have been like, prosecuting this emotional case, and someone who was representing himself.
We will go back to regular coverage and rejoin you at 1 p.m. for the press conference with the DA.